Thanks, everybody. This session is about, it started off being about environmental claims, and then we sort of thought that, well, probably we need to cover ESG, which is the environmental, social, and governance. So a lot of the things that we're talking about are going to be relevant to all three of those alphabets. And the reason why ESG claims are becoming more and more prevalent in what we're seeing is partly because there is more regulatory focus around what institutions are doing. There is the Paris Agreement that is being used as a means to sort of hold companies and organizations accountable. There is things like TCFD, there's things like SFRD, there's various disclosures that companies are having to provide in relation to what they're actually doing, as opposed to just having a sort of sustainability strategy, for example. And so that is creating the foundations of data and material out there that can then be used to sort of bring about these claims. That is what is being used. The why ESG claims are becoming more prevalent is probably more a sort of societal issue, where actually people and organizations are looking at the world around us and are kind of thinking, right, well, it's all well and good having policy, it's all well and good having commitment, but how do we bring about behavioral change? And that's what's driving some of these claims. And so the way I like to think about where's the sort of actions coming from, or how do you think about the group actions and class actions in this space is to actually think about the perspective from which these claims are being brought. And the way I divide them is you've got the activist perspectives and you've got the NGOs. You've got the claimant law firms and litigation funders. You've got the consumers and employees in organizations whose ethical values are sort of slightly mismatched with their own organizations. And then you've got the institutional investors, which are sort of sitting on funds and finance, and they're the ones sort of helping to drive some of these projects that, you know, some of these activists see as objectionable. So looking at each one of those, you've got the activists that want to bring these claims because they want to see behavioral change. They want to drive organizations in a particular direction. They want to use the sort of legal tools that we'll come on to talk about to bring about change. You've got the litigation funders and the claimant law firms that are looking at it and thinking, well, actually, there is a rule of law question, but also there is a damages question. And actually, this is a good way to sort of bring about large claims for substantive amounts of damages, again, and we'll come on to talk about some of these matters in terms of the economics of it. You've got the consumers and employees and stuff who are sort of feeling like, actually, well, if I have bought a particular product and I expected it to behave in a particular way, and I suddenly find out that it's not quite behaving, and I may have invested in a particular product because my social and ethical values were aligned with it, and all of a sudden I find that they're not, then I feel aggrieved, and I want to participate in a particular action. And at the end of it, I may get damages, I may not get damages, but you know, there was a good reason why I invested in what I invested. So that's the sort of perspective that they're coming from, I think. And then you've got institutional investors that are probably facing pressure from both ends because they've got their own sustainability and ESG policies and strategy, which they are being held accountable towards by these other three groups that I've just mentioned. But they've also got the pressure of generating returns on investment, and they've got the pressure of sort of holding, you know, being able to deliver on what they have invested and for their own investors. And so that's where we are seeing actually a lot of institutional investors are becoming claimants rather than just defendants. They are participating in large group actions, partly because, as I say, their own governance requires that they do, and partly because they have said that this is what their sustainability policy would be, and in order to demonstrate that they're actually complying with their own sustainability strategy, they're having to participate in some of these claims. So that's the way I sort of tend to look at this very, very broad topic. You then have the routes to bringing group action and class actions, and I'm sure you've heard a lot about the difference between the two in this jurisdiction throughout the 2 days. But from a sort of English law perspective, the way I see it again is You've got the sort of FISMA claims, which is claims that are brought against listed companies, which is a securities litigation. And I think there's a panel after this that's going to talk a lot more about those. But that sort of lends itself to be able to bring claims, particularly in the ESG space, because a lot of the reporting that is being done by listed companies, a lot of the data that is being put out there by them, sort of lends itself to a Section 90A claim, for example, or where there are various listed companies that are putting up prospectuses out for funds and stuff, that lends itself to a Section 90 claim, which is quite easy to bring if you want to bring it on behalf of a particular group. You've then got the sort of mis-selling type claims, which we've seen in this jurisdiction, which is, it's not really a class action, but it can be potentially brought as a group action where you may have various products that are sold that claim to do certain things in relation to ESG credentials, but don't quite meet that need, and therefore sort of falls quite easily into the sort of misrepresentation type bucket. You've got the derivative style action, which we've seen being tested, and again, we'll hear a bit more about that shareholders can bring on behalf of a company against its directors. And again, that's sort of a route that's being weaponized in this space in particular. And then you've sort of got the Consumer Rights Act sort of mechanism, which is a sort of classic class action type regime, which is also being used in this jurisdiction to bring these sorts of claims. And again, we'll hear a bit more about it. And the final one is just a sort of traditional claim against a large organization by a group of people where they basically say, and we've seen examples of that where there might be an oil spill in a sort of foreign jurisdiction, and a group of individuals in that particular jurisdiction are aggrieved by what's happened. They want to bring a claim against a company that's headquartered in this jurisdiction, and it's a sort of standard tortious claim for a sort of duty of care type claim that is being used to bring these sorts of claims. And you can sort of put it into the environment bucket, and some of these claims have been out there for years. They're not new. It's just that people probably haven't thought about it as a sort of ESG claim, and now people are starting to sort of badge some of these claims in that way. So that's the sort of overview in terms of the perspective of the different claimants that are trying to bring these claims, the different routes to which we can have these claims in this jurisdiction. And a lot of what you're going to hear is going to be unpacking some of these issues in terms of why this has become such a big deal in this jurisdiction, why it's becoming bigger, and what the novel ways are in which people are using the current regime to bring to light some of these issues. I'll sort of hand over to Jeremy at that point in time to sort of talk about some of these novel routes that are being deployed over here.
Thanks, Kushal. And I think it's a good introduction into the types of mechanisms that people are using to bring these claims. And I think you touched on this idea of a large group of litigants in the current environment, which are seeking not just sort of commercial or financial objectives, but are seeking to push forward change in society and government actions and corporate actions. And I think what that's really driving is quite innovative ways of using existing legal frameworks and really testing the boundaries of those to see what can be achieved. And I think and I sort of wanted to touch on two sort of types of innovation or creativity, which I think we're seeing in the market at the moment. The first being kind of procedural creativity, so using kind of existing procedural tools in new and interesting ways, but also innovativeness in terms of substantive legal theories, and in particular how that's kind of evolving in parallel across a large number of jurisdictions around the world. And if we sort of think about climate change in that particular context, clearly this is a top of mind issue in virtually certainly every Western jurisdiction and many other jurisdictions around the world. And I think that has meant that we are increasingly seeing attempts to piggyback off different legal theories around the world. So I'll touch on both of those types of creativity and thinking about the types of claims that are coming before the courts and also in other tribunals and sort of quasi-judicial forums at the moment. So I think on this first point of procedural creativity, I mean, to give a couple of examples of this in the UK context, recently we've seen the derivative action, which Kushal mentioned, being used in quite interesting ways against directors of companies. So there's two cases recently, McGoffney and University Superannuation Scheme, as well as Client Earth and Shell, both of which you've had groups of claimants or NGOs seeking to argue effectively that the climate strategy set by the directors is inadequate and doesn't meet the requirements of Section 172 of the Companies Act, which is what effectively sets out the factors that directors need to have account in setting the strategy for the company. Now both of those cases were dismissed, but I think they're really interesting in showing the kind of substantive challenges, but using to a corporate climate strategy, but using a tool against the directors to kind of bring these issues to the fore and really focus the attention of directors in that particular context. There's another sort of recent example which is sort of in its infancy at the moment in the UK, which is a collective action against some of the water companies. So several of the water utilities are alleged to have provided misleading information to their regulators about sewage discharges in the UK. And it's quite interesting from a procedural perspective because this is a case that's been brought as a competition law case, so an alleged breach of dominant position, which has facilitated this allegedly misleading conduct. And I think that's quite interesting because that's one of the reasons I think that the case has been framed in this way is that one of the few mechanisms through which opt-out collective actions can be taken in the UK is where there is for competition law claims. So I think the fact that it's been, on its face, very much an environmental claim, but being sort of put through this lens of competition law and consumer rights law, I think is a very interesting example of the sort of new interesting theories and ways of trying to develop these arguments. So that's obviously not one that's in the climate context, but nevertheless one that sort of under this broader ESG rubric I think is an interesting trend. And there's another sort of example which I think is outside the courts, but what we're also seeing is soft law or quasi-judicial forums such as the OECD national contact points for business and human rights, as well as sort of regulatory bodies like the Advertising Standards Authority being used as forums to sort of test some of these theories and really start to develop them by claimants. And it being quite a low barrier to entry way for claimants to actually sort of highlight some of these issues and going back to the point that these are not necessarily all financially motivated claims, to draw attention to these sorts of issues in public forums and have those claims addressed, or at least have attention drawn to them. So that's sort of on the procedural side, and I think thinking then to the substantive nature of the claims and sort of some of the interesting theories that are being tested by claimants. I think what's quite interesting in this context is that, as I mentioned before, you're seeing sort of very different legal systems address very similar, overarching principles. So, what are the responsibilities of different actors in society for climate change? What is the role of government, and where does the role of individuals or companies start and the role of government stop, if at all? Is it a sort of a demand side issue? Should it be about the demand for fossil fuels, for example, or should it be about the supply side? And I think a lot of those questions are starting to be addressed and grappled with by courts in a number of jurisdictions, and then cited across into pleadings in other courts. So I think that's quite an interesting trend to see those issues dealt with in that way. And I mean, just to give a couple of examples of the sorts of claims which are arising in that context. Obviously, the Shell Mayo Defensie litigation in the Netherlands was sort of one of the first cases where a court has found the existence of a legal duty on a corporate, in terms of being required to reduce emissions. and that case is currently under appeal, but I think it's an interesting example of, the courts in a jurisdiction which has a sort of flexible, tortious standard and an open norm to really test what those boundaries are in that jurisdiction. And then we are seeing, those cases cited in other jurisdictions. So, whether it be in the US or in New Zealand, for example, there's a tort case, much more of a common law, classic tort case around the tort of nuisance, and seeing whether some of those broader principles from cases like the Shell litigation in the Netherlands can be applied in a common law context, and drawing interesting analogies between industrial revolution cases from England around the pollution of rivers and waterways and air pollution, and really sort of quite creative ways of reformulating existing standards into ways that suit the current environment more clearly. Now, I think a lot of these are really pushing the boundaries of what courts are willing to go to, and I think the fact that the Klein Earth litigation I mentioned before was quite convincingly struck out at first instance by the High Court here as an example that there are barriers to this, but I think the fact that these cases are developing, claimants are really trying new theories and being willing to test things across different jurisdictions is quite an important principle for people to be thinking about and watching closely. Just to give one other example of these sorts of cases, I mean, I mentioned in the Netherlands you had the Shell Mayu Defensie litigation. In Germany, and it's obviously looking at the supply side of the energy system and looking at a producer of fossil fuels. In Germany, you had a similarly framed claim against BMW, seeking an injunction to stop it selling vehicles with combustion engines. So again, you're seeing very similar concepts and similar ideas being tested in jurisdictions and sometimes ending up with different results. So we're very much in this stage at the moment of many different claimants with many different motivations, testing the boundaries of these legal theories, and sometimes successfully, sometimes unsuccessfully. And so I think we're going to see a lot more of that and a lot more piggybacking on some of these successful and unsuccessful claims around the world in future. So I think with that, maybe I'll pause there and pass over to Deborah, who will change tack a little bit and dig into one of the current environmental issues in the US.
Yes, thank you. So I think Garrett and I are going to talk about the problem and litigation over and regulation over what's known as PFAS, which some of you may know about and some of you may not. So I'm going to start by explaining what it is, and then there's been a lot of interesting litigation in the United States that has proceeded in some unusual ways. And it sort of, as that litigation ramped up, regulatory actions have also ramped up. So it's been kind of an interesting, to look at both sides of this process. So let me start by defining it. PFAS, P-F-A-S, it really stands for per and polyfluoroalkyl substances. So these are chemicals, man-made chemicals. There are thousands of them. This is not just like one particular chemical. They have certain things in common. They've been in use in industry and commercial applications since the 1940s and 1950s. So these are long-standing substances that have been in use for a long time. There are newer ones, there are older ones. There's some chemical differences, but we're not going to get into the science part of this at all. But these are products and these are substances that everybody encounters. So they are used, they have water-resistant capabilities. They're used in cookware. They're used in water-repellent fabrics. You might wear Gore-Tex, or you might have a camping tent that's water-resistant or water-repellent. Probably has some of these substances in it. They're used in cosmetics. They're used for firefighting purposes. You probably may have heard of firefighting foam, which is sprayed to help put out fires, which is actually very important. They are used in candy wrappers, fast food containers, medical devices. They are used in shampoo and nail polish. It's just everywhere. And these are substances. One of the reasons that they're used so often is because they don't degrade. They're called forever chemicals. So they are always there. They're very mobile. So they just get into the water, they get into the air, and they end up in different places. And I just saw a study that said 97% of the people in the United States have PFAS in their blood. So it's pervasive, it's everywhere. Polar bears have PFAS in their blood, and they don't really travel that much. They actually stay in a particular part of the world, and it's not an industrial area. So this is just all over the place. And so now the struggle is, what do you do about this? And is it harmful? So there's a big debate about whether there's harms, but the United States EPA says that there's linkages to certain kinds of human health effects. This is a debate that's going to go on for a while, but I think the CDC, the Centers for Disease Control in the US, is also listing some potential health effects. And there are lots of factors involved in that. I don't want to suggest that if you've picked up a candy wrapper, all of a sudden you're going to have some sort of terrible effect from it. And I think they are all different. There are some differences, and individual people's circumstances create differences, but they are capturing the attention of a lot of people and a lot of regulators about what should we do with this particular substance. So I want to talk to you about a couple of cases that have gone on in the United States, because I think they're pretty interesting and just from a purely academic perspective, and then they have achieved certain results that are interesting. So a few years ago, there was a case, I'm going to call it the C8, the DuPont C8 case. It's a case about PFAS getting in the water of a local community as a result of discharges from a DuPont facility, and it's in West Virginia in the United States. So it's a relatively small community. It's a lawsuit about it. Interesting settlement that occurred. But there was a settlement that where both parties agreed to have a science panel study the chemicals and whether there were certain health effects that could be linked to these chemicals. The science panel comes back with their report, and they listed about 6, I have a list someplace, but about 6 different health effects that they said were linked to the exposure. And as a result of that, after further issues and further litigation, there was a settlement of about $670 million for 3,500 people in that particular area. There was also the ability of people to bring separate lawsuits, particularly if they had one of those linked conditions. So that litigation has continued, and one of the verdicts was very substantial, a $40 million verdict for one individual who brought a separate action. So that's one of the reasons I mention that case is because, first of all, that procedure is quite unusual, to have some sort of settlement science panel study something and then come out with findings that then guide the next layer of settlement. But also it was the subject of a movie, so if you're interested at all, the movie is called Dark Waters, and it's about one of the lawyers primarily who really kind of pushed this case for a very long time to get it going. So that's maybe a pretty significant example of litigation that's been started, and that's on the personal injury side. There's what is happening now that is capturing a lot of attention is there's about 15,000 cases filed around the United States in the federal courts. I'm going to separate out federal courts from state courts because we have 2 different systems in the United States. So these are federal court cases. They were all consolidated for pretrial purposes by the panel on multi-district litigation. I think we've talked about MDL's multi-district litigation earlier in this conference. And so they were all aggregated in a federal court in South Carolina, and litigation has proceeded there on some of the basic issues in the claims that are being made. So the cases, I think, were consolidated around 2018. About 10 months later or so, there was I think if I have my dates correct, a science day where there was, all the parties brought their experts in and had sort of address a lot of the scientific issues that are there in these cases. And that's actually a procedure that is used not infrequently in the US for when you have major consolidations of claims that have significant scientific issues. So we have a science day, all the experts come in, they have different, obviously, opposing points of view. Science day occurs. The court structured the litigation to go on two tracks. One was the liability track, which was purely legal. Is there a basis to just dismiss these cases? And the other was to create a bellwether trial, case to actually test out the liability and damages. So there was proceeding on two tracks. Summary judgment was denied for the defendants on the liability side. The bellwether case continues to proceed forward. In the meantime, the court engaged a mediator and instructed the parties to start talking about settlement processes. Now remember, these are all individual cases that have been filed. They're in multi-district litigation. Parties reached a settlement in June or July of 2023, and part of that settlement was to create a class action. And so to implement the settlement, they filed a class action complaint in the multi-district litigation against the two defendants that had agreed to settle. They're two separate actions. One is 3M, one defendant is 3M, the other one is DuPont. The parties to the class action, the plaintiffs, are not individual consumers or individuals claiming personal injuries. These are public water systems. So the plaintiffs in this class action are public water systems who say they are now subject, they have to clean up the water. I'm paraphrasing a little bit, there's much more to it. But in order to meet regulatory standards, to avoid potential health effects, these public water systems have to construct mechanisms to filter out PFAS if they can, which I think is a logistical difficulty, find other sources of water. At any rate, they're going to incur substantial expense to try to ameliorate and remediate the presence of the PFAS. And this is across the entire United States. So right now, that settlement notice went out. Objections were due on the 11th of November, which is just a couple of days ago. There were objections filed. And you did the notice, right? So yeah. So I couldn't hear that, but. Yeah, I haven't had a chance to read the objections yet, but I think some of them go to the indemnity issues that are in the settlement. But at any rate, there is this class settlement. It's got preliminary approval. The final approvals hearings are scheduled for later. I think one in December, one in February. I'm not quite sure exactly the timing of the two, but so they are still in the process. They don't have final approval yet, but they have a very well-developed and elaborate system of allocating funds to different public water systems. There's a grid, like a potential grid. I don't think these numbers are guaranteed at all, but they go all the way from, I think it's something like $36,000 to $77 million. The allocation depends on what population you serve, how much water flow there is, and what level of PFAS you're detecting in the water. There's still more to come on this, but the dollars are very significant. 3M agreed to pay between $10.5 and $12.5 billion for this settlement, and DuPont is almost $2 billion. So these are very significant dollars, and this is a tip of the iceberg because this is just some of the public water systems in the country. And then before I turn it over, I have one more case to mention. There's a case now pending in the United States Court of Appeals for the Sixth Circuit. There was a class action certified in a court in Ohio that sought injunctive relief to create a national science panel to study PFAS and determine what conditions could be, what kind of health conditions could be caused by it, which is kind of a thing that you normally see in regulatory actions or legislative actions anyway. This was filed as a class action, a mandatory class action, no opt-out, certified by the district court in Ohio. It's up on appeal because what they're seeking is mandatory injunctive relief. What they're really seeking is for the companies to fund a scientific study. And so the argument was just held about a week or so ago. I don't think I've noticed that a decision has come out. This is interesting because it went up as a interlocutory appeal of the class certification decision, which means the court really wanted to take this case. So I suspect they're going to reverse it, but we'll see what happens. So I'm going to stop there because we got to talk about Europe. And anyway,
yes.
That's what's going on in the U.S. So.
Thank you, Deborah. So I'm a Brussels-based litigator. I'm dealing with high-profile cases. I started my class action career in securities. I participated in the Fortis case, which was a multi-jurisdictional case with a settlement of 1.3 billion some years ago. But then I started the Dieselgate case. I participated in the Volkswagen case, and now there is the PFAS case, and that's what I want to talk to you about. So PFAS is a highly toxic forever chemical, and it's a badass, it's a bitch. Why? Because scientifically, we know it causes at least 3 kinds of cancer. It causes immunity diseases, it causes fertility problems, and a lot of other diseases. And the problem is that we are talking about a family, according to the American EPA, of 12,000 applications, 12,000 different PFAS. And the oldest one, they are called PFOS and PFOA. And they stopped producing these older applications many years ago, because at that point, it became publicly known that these applications were harmful. But it lasted a lot of years before the public really realized it. And documents show that the big producers in the world, like DuPont, 3M, Daikin, for example, they knew these chemicals were highly toxic already in the 60s and the 70s. And still, they continued producing, and they continued inventing new applications. And there is a lot of scientific research on the older versions, but on the new versions, and I'm talking about thousands of applications that are still produced as we speak today, everywhere in the world. There is no research. Research is just starting. Many experts suggest that 1 nanogram of PFAS on a liter of water is the maximum. 1 nanogram. You know what a nanogram is? Everything above could be dangerous for your health, for the environment. In Antwerp, because I'm going to talk to you about the case in Antwerp, but also the case in Dordrecht, because it's all over Europe, all over the world, they found PFAS on the North Pole and in Tibet. Can you imagine? Because all of us, we have PFAS in our body, but we don't know how much, and yet most of you never heard of PFAS, which is quite remarkable. So it's a big family, and in Antwerp, they found out close to a factory of 3M, the American 3M, that there was not 1 nanogram per liter water, but 68 million nanogram per liter water. So it's huge. And I also found out, which will lead me to the case before the courts in Belgium, they also found out that people living around the factory had 7,000% more PFAS in their blood than the maximum allowed in Europe. So it's a huge problem. And I think in 50 years, if we come all together, we're still alive at least, we will still talk about PFAS. PFAS is, in my opinion, the biggest environmental challenge, pollution of our century. PFAS is really big. So what is the situation in Europe? Because I think in America it's clearly high noon, and in Europe we are still asleep, we are awaking. And, but there is some movement. And if you want to know more about PFAS, you should tap on your Google or Yahoo Le Monde PFAS, because the Le Monde conducted a study some months ago together with experts and other journalists, and with peer review. It's a very good article, and they developed a map of Europe. I have it here, I can't show it, but if you look at it, it shows the contamination, the PFAS contamination in Europe, and it's terrible. And UK, for example, is red, and red is bad, red is very bad. Scotland is still okay, but England is very bad. Belgium, very, very bad. France, bad. The Netherlands, bad. Germany, bad. Denmark, bad. You see, it's a concentration, the north of Italy. And what did they find out? Well, there are 20 producers of PFAS in Europe, which is interesting from the point of view of a litigator or a litigation funder. 20 producers. We know their names: 3M, Daikin, DuPont, Chemours, etc. There are 232 users of industrial users of PFAS, because the problem is not only producing PFAS, it's also working with PFAS, because PFAS travels everywhere, through the air, through the rain, through the rivers. It's everywhere. It can be dust. Do you know, sometimes in summer, on a morning, you discover a thin layer of sand on your car. It's coming from the Sahara, here in England and in Europe. So you can imagine how PFAS can travel through nature. So they also discovered, I also have to add that in the United States there are already litigations against the industrial users of PFAS, like McDonald's in the cups, coffee cups, Burger King, Coca-Cola, and cosmetics, L'Oreal, Rimmel, because if you use your lipstick, ladies or gentlemen, nowadays everybody uses lipstick, and it's full of PFAS, so you have to take care. They found out in Europe there are 17,017 spots with very high toxic PFAS, 17,000, it's a lot. And plus 21,500 possible spots, altogether 50,000 spots with contamination of rivers or soil in Europe, just in Europe. And 2,100 hotspots, meaning very, very high concentrations, very high concentrations. And do you know where the hotspot, not of Europe, but worldwide is? In Belgium, in Antwerp. And that's the case we dealt with and we're still dealing with, because we are looking at it from a European perspective. We are working together with lawyers now in Italy and in the Netherlands. We are looking for a cooperation for lawyers in Germany too. And I'm humble, but at the same time proud that we conducted a bellwether litigation against 3M. And we obtained a judgment in May condemning 3M for all the damages which are caused by PFAS in the region of Antwerp. And we're talking about more than 200,000 people living in that area. So now we are constructing the mass, it's not a class action, it's basically a mass action. We also look at the criminal aspects, it's also very important. And in Belgium, there is a new bill, it's coming in a few weeks, and we kind of anticipate it because the bellwether principle, which is very common in the United States, I just talked to Deborah, is it written in any bill? No, she said it's the practice of the law. It's more like jurisprudence. Well, actually, Belgium will be the first European country creating a kind of precedent law because a new bill is coming, and the new bill will say, not with as many words, but basically it would say that if an individual is litigating against a big company and wins the case, all individuals in the same position can use the judgment as a precedent. And that's what we did in the 3M case. Because we knew the bill was coming, it will be retroactive, and we're going to use the bill. And I think it might make Belgium to a relevant country in class actions and mass actions. And I don't want to compete with the Netherlands, because we know the Netherlands has a very good law system, for example, the WCAM and the WCAMCA. They're good laws. We used them in the Fortis case, and the Netherlands is becoming more or less a marketplace for class and mass actions, but I think Belgium might start competing with this new bill. So we are still investigating it. It still has to be voted by the parliament, but it's coming before Christmas. So that's what happened in Belgium. And what can I say? Other hotspots where litigation is starting, it's not a lot. Europe is awaking now. Most countries are still asleep. In France, in Lyon, there is an area around Lyon with 350,000 people living there. There is the case of a 2-year-old baby with testicle cancer. Testicle cancer, 2-year-old baby, yeah, with a causality, a link to PFAS, scientifically proven. And that's the case that initiated thousands of other people going to court in Lyon. The producer over there is Arkema and Daikin. In Dordrecht, in Holland, people are awakening around a factory of Chemours. Chemours is a spin-off of DuPont. There are 200,000 people living in that area. Many of them have high levels of PFAS in their blood. In the coming years, there will be a lot of misery. There will be cancers, immunity diseases, people will die of PFAS. In Tricino, in Italy, close to Verona, in Venice, the Venice province, there is also a big case. Same thing, 350,000 people living over there. It's a criminal case. In Sweden and Germany, also cases are emerging. So that's just a recap. And Greta Goldenman, who is a PFAS expert, I think she's from Sweden or Denmark, she says that the estimate of the exposure in Europe today of 170 billion is clearly underestimated. It's a tragedy. I think a lot of people are in need of legal help. I think we have a certain duty because class actions are not only economics, they also have a social mission. Thank you.
I guess we're done.
Thanks.
We're happy to take any questions. We're conscious of time, but if anybody did have questions, we're happy to take them.
Just a quick question on the PFAS. We talked a lot about the US and Europe, but what's the exposure in the developing world to manufacture of these same chemicals? And it's a global class action symposium. What sort of rights do you think people will have in those jurisdictions? And is there a conversation to help people in those parts of the world?
Can you specify your question? You want to know what?
Sorry, the stage
because
is
the first
with the questions.
part, yeah.
With the developing world,
yes.
Will they have the same issue?
Well, we have a map of Europe. We don't have a map of the States, for example, and we don't have a map of Africa. But I'm convinced there is a lot of production over there too. It's everywhere, you know. And a country like India, Or China, I think it's a red map, so it's produced everywhere in the world. And we know that all the big factories, they have their plants everywhere in the world. So clearly, yes.
I think the other thing to add to that is that we are seeing this already, where jurisdictions like England are being used for claimants from foreign countries to bring their actions here, because a lot of these manufacturers and producers are headquartered here, and there is a legal system that enables these claims to be brought. So it is quite possible that jurisdictions like England, like the US, will be used by citizens in the developing world to bring these actions, whether that's as a result of tortious duties of care or to sort of piggyback on the back of existing actions. So I think that is probably likely.
I think we're done.
Any more questions?
Time's up.
Okay, well, we'll call it a day there, but thank you very much for your attention.
Right.